Justice V. Ramkumar delivers a lecture on charge, discharge, and framing of charges. A brief overview of the speech delivered by Justice V. Ramkumar, former judge of the Kerala High Court, on charge, discharge, and framing of charges, discussing the legal principles governing the framing of charges. Emphasizing the Supreme Court's ruling in William Slaney v. State of Madhya Pradesh, AIR 1956 SC 116. The decision underscores the judiciary's role in safeguarding procedural fairness while ensuring justice. Justice Ramkumar stressed that framing charges accurately ensures fair trials, protects the accused from prejudice, and upholds natural justice.
To Mrs. Waters and the who the Mrs. Waters was belonging to Jabalpur in Madhya Pradesh. She had a son and a daughter. Donald Smith was her son, and Beryl, who was examined as PW 13, was her daughter. Beryl, the daughter of Mrs. Waters and the sister of deceased Donald, was residing in the above house belonging to William Waters, Mrs. Waters. The mother and son Donald Smith, mother and her son Donald Smith, were residing elsewhere. The person who was attacked and killed in the occurrence was the said Donald Smith, who is a brother of Beryl, PW 13. The accused persons in this case were one William Slaney, first accused, who was the appellant before the Supreme Court, and his brother Ronnie Slaney. Even though Beryl was married to a gentleman in England, her husband, there was usual family bickering between them, which escalated into great quarrels between them. Finally, her husband turned her out, and she had come to India, to Jabalpur, and was living in the house of her mother at Jabalpur. That is Mrs. Waters' house at Jabalpur. The first accused, William, eventually fell in love with Beryl, who also reciprocated his affection towards her. But she could not marry him because her husband had refused to give her a divorce. Deceased Donald, the brother of Beryl, did not like the intimacy between his sister Beryl and William Slaney. Donald used to make attempts to separate his sister from the first accused. On the evening of the date of occurrence, Donald Smith and his mother paid a visit to Beryl's house. To their dismay, they found William Slaney, the first accused, already in that house. There was a quarrel between Donald Smith and William Slaney. William asked Donald Smith to go away from the house. Unwillingly, William Slaney left the place, but returned a little later with his younger brother, Ronnie Slaney. William Slaney called Beryl, who was in the first floor of the house, and asked her to come down to him. But Beryl did not come down, but instead it was Donald Smith who came down to the courtyard. During the quarrel that ensued between William Slaney and Donald Smith, William slapped Donald Smith across his face. When Donald, who was a stout and well-built man, shook his fist against the face of William Slaney, the latter snatched a hockey stick from his brother, that is Ronnie Slaney, and dealt a blow on the head and 2 blows on the hips of Donald Smith. The skull of Donald was fractured in that single blow, and he died in the hospital only 10 days later. William and his brother were subsequently charge sheeted by the police for an offence punishable under Section 302 read with Section 34 of the Indian Penal Code for intentionally or knowingly committing murder of Donald in furtherance of their common intention. Now, Section 302 IPC is presently Section 103 of Bharatiya Nyaya Sanhita, BNS, and Section 34 is presently Section 3, Clause 5 of BNS. During the trial of the case, it was proved that the fatal blow was dealt with by William, the first accused. Even though the skull of the deceased was fractured in that blow, he had survived for 10 days in the hospital. The postmortem doctor deposed before court that the head injury sustained by Donald was, though of a serious nature, it was only likely to result in fatal consequences. The trial judge acquitted Ronnie, the second accused, but convicted William A1 for murder and sentenced him to imprisonment for life. This was affirmed by the High Court of Madhya Pradesh also. It was aggrieved by the said conviction recorded and sentence passed against William Slaney that he approached the Supreme Court. Now, in the Supreme Court, William Slaney, the first accused, argued that since he, along with his brother Ronnie, was charged for the offense of murder, punishable under Section 302, read with Section 34 IPC, and when Ronnie, the second accused, was acquitted, the liability of William, first accused for murder, ceased to be constructive. It was no more constructive because there was no common intention proved. And it became direct, and therefore it was impermissible to convict him without a separate and independent charge under Section 302. Viewers, I suppose you got the point. They were charged, both the brothers were charged under Section 302, read with Section 34, on the ground that the murder was committed by both of them in prosecution of the common intention of both.